Hello, I'm Dominic Walker, JMW's Inside Man. I'm with David Smith. David is a partner in JMW's Commercial Litigation Department, and one of David's specialisms is data law, to the point that David has written a book on the application of data law. Hello, David.
Hi.
David, so we've seen in the press about these football players who it's rumoured are taking legal action in relation to their data. I just wonder if you can give me an idea of what's happened, please.
Well, obviously, I've only seen the press stories, so I've seen a limited amount of information, but it appears that I'm no sports expert, I should say immediately at this point, but as I understand things, in professional football, an awful lot of data is collected about players as they're playing these days in terms of how many times they've headed a ball, how they've moved on the pitch, and all the rest of it. And this is used both on TV by football pundits. We've all seen the wonderful play-by-play whiteboards with circles appearing and arrows going everywhere. I always look at them in bafflement, but I'm sure they mean a lot to some people. And it's used by bookmakers as well for certain types of bets, because of course you can bet about how long someone had the ball and all kinds of weird and wonderful things. And of course it's used by coaches as well. It says it's used by lots of people. The question that's now being posited here, I suppose, is who owns that data? Because of course it's currently collected without any particular permission being given by the people it's being collected about. And they're not paid for it. I mean, above and beyond being paid to play football in the first place. And so I think that their position is that they want to be paid for it one way or another. I mean, that's the long and the short of it, isn't it? The thing that's a bit weird, at least in the case law or in the reports about the case, is that they're talking about the GDPR, the General Data Protection Regulations, which I'm sure a lot of people have heard about and read about, which is the big EU data protection regime, which is still being retained post-Brexit. And that I find a little odd, because one of the things that's really interesting about the GDPR, and one of the reasons it's so complicated, is that the EU was desperately keen to give people rights over their data, but absolutely not to alter the right of companies to own data. So it was very clear that the collection of data and the creation of value with this data, which is essentially what's happening here, should not be disturbed by the GDPR. So I find it hard to understand how somebody can utilize the GDPR to assert their right to be paid for their data. There's nothing in the GDPR that in any way suggests that people are entitled to be paid for their data. In fact, the opposite. That's the reason it's complicated is precisely because we're not doing that. What we can potentially do is make claims against people where they've used our data without the right legal permission to do so.
Yeah, so you talk about permission, and that leads nicely, as you say, into consent. And I suppose in data protection language, when we're talking about using personal data, it's processing personal data. So is consent required for organizations to process, to use that data?
Well, again, this is a big change with GDPR. Lots of people think that consent's really important, but it's not actually. It used to be the be-all and end-all of data. And if you go to other jurisdictions in America and now in China, consent is what it's very much about. But actually, the GDPR has tended to move away from consent, partly because consent was being misused in the sense that you would have this kind of forced consent where you would sign a terms of business or some kind of tenancy agreement or something else, or a contract, and squashed into it in some little bit of small print, which you never read, was this bit saying, oh, by signing this agreement, you've consented for us to use your data and you can't revoke it. So the GDPR sort of moved away from this idea because it doesn't make a lot of sense, and said that consent is always revocable. And in fact, there are other ways of using people's data that don't rely on consent. So the point of view, again, with football is if it's a consent issue, all they have to turn around and say is, I revoke my consent, and the data can't be used.
For organizations who have maybe received some kind of legal letter and they want to defend their position, what's your practical advice? What should they be thinking? Well,
I mean, they clearly need to talk to some specialist advisors, but there needs to be a breakdown of the claim into the various sort of different rights that are being asserted here. I'm no specialist on people's rights in images and so on. I've got much more qualified colleagues, but I think from a data protection point, you would need to look at exactly how they were basing their claim. But I have a hard time understanding how that claim can work. And so that bit of it can be responded to fairly firmly, I suspect.
David, thank you very much for your insight. And as you mentioned, we do have colleagues as well who can advise on a variety of sports issues. So if you'd like to contact the sports team, you can email insideman@jmw.co.uk or call 0161 82 81 999.
I'm Dominic Walker, JMW's Inside Man.